Well, good morning, good afternoon, and good evening. Thank you for joining us. My name is Jimmy May, and I'm delighted to chair this panel on climate change and the rights of the child, and to join as co-sponsor on behalf of the Global Environmental Rights Institute and the Dignity Rights Project at Widener University, Delaware Law School. If you're itching to learn more about the latest developments in adjudicating rights of children in the face of the Anthropocene, you've come to the right place. First, make no mistake, children are acutely affected emotionally and physically by adverse environmental conditions, including climate change. Children are also rights holders. The United Nations Convention on the Rights of the Child and several regional conventions, including the American Convention on Human Rights, recognize the rights of children. Many countries recognize the rights of children as well. The United Nations Human Rights Council has adopted a resolution specifically addressing the rights of the child to a healthy environment. Agenda 21, the Sustainable Development Goals, and the UN 2030 Agenda all recognize the rights of children and future generations to a healthy environment. This panel will address how children are adjudicating climate change and the climate crisis at the front lines, including internationally before the United Nations Committee on the Rights of the Child and the Inter-American Commission on Human Rights, and domestically in countries including in Australia, Germany, the United States, Colombia, Netherlands, Pakistan, Norway, and elsewhere. This session will examine special issues in adjudicating these cases on behalf of children and future generations. And we have a top flight lineup. It's an honor to introduce them as colleagues and as friends. Brianni Eels is a climate change and environmental lawyer working in the Asian Development Bank Law and Policy Reform Program. She's led research and writing for ADB's four-part report series, on climate change, coming soon to a court near you, a fantastic read. The reports are comprehensive in the review of climate law, policy, and litigation in Asia and the Pacific. Brianni has previously worked in mining projects, advising on environmental and social compliance, project risk, sustainable development, resettlement, and Indigenous peoples engagement. I got to know Brianni and her excellent work in this arena, beginning at an Asian Pacific conference on the rights to a healthy environment and climate justice in Pakistan. And I've had the privilege of co-sponsoring or working with co-sponsors ADB, UNEP, and Delaware Law School on these sorts of conferences. Julia Olson will go next. And she is the founder, executive director, and chief legal counsel of Our Children's Trust, a nonprofit public interest law firm that provides strategic, campaign-based legal services to youth from diverse backgrounds to secure their legal rights for a safe climate. Julia founded that organization in 2010 when, as a young mother, she realized that the greatest threat to her children and children everywhere is the climate crisis. Julia is lead counsel in the famous case of Juliana versus United States, the constitutional change case brought by 21 children against the United States government, arguing that it was violating their right to life, liberty, and property under the Due Process Clause of the United States Constitution, and also the public trust doctrine. I had the pleasure of meeting Julia for the first time at an annual environmental land, air, and water conference in Eugene, Oregon. Remember that, Julia, a decade ago, and have admired her work and her world-changing perspectives on law ever since. And then Ramin Pejan will be our third speaker. He is an attorney with the international program at Earth Justice, because the earth needs a good lawyer. I got that plug in. Previously, Ramin worked for the United Nations Office of the High Commissioner for Human Rights and the United Nations Environment Program on the links between human rights and environmental issues, and as senior counsel at the New York City Law Department's Environmental Law Division, one of the largest in the world. Ramin is co-counsel in the climate change complaint brought by Greta Thunberg and 14 other children before the United Nations Committee on the Rights of the Child. I got to know Ramin during his visit as a scholar in residence in global environmental constitutionalism at Delaware Law School in 2016, and while he served as co-editor and co-author with John Knox on the book, The Human Right to a Healthy Environment, which Cambridge published in 2018 and should be required reading. This panel will proceed in 3 parts. The first, brief presentations from each panelist, followed by a discussion amongst the panelists. And then for the third part, the question and answer session from the audience. That's you. So with that, we encourage you to post questions in the Q&A. And with that, without further ado, please let me turn it over to Briony. The floor is yours. Thank you so much.
Hi, Jimmy. It's such a pleasure to be here. So let me start with a story. A story by Yanis Varoufakis, Greece's former finance minister. It's 2011. Greece was gripped by economic depression and citizens were protesting the terms of the proposed bailout. There was a picket line at Parliament House, and one night, a young, thin, frail woman climbed up the wall and she almost fell, so caught the eye of a very prominent politician. And he looked at her and he said, "Who are you? Who are you to tell me how I will vote?" And so she responded with such dignity. Her response was, "Who do I need to be?" I don't know about you, but I ask that all the time. But I tell this story, it resonates for me, but I think it resonates for this discussion. And there are 2 themes that I want to explore in the brief time I have. And firstly, who do today's youth and future generations or future holders need to be for the law to listen to them? How are they framing their arguments in court? And secondly, there are some emerging cases that say that youth citizens should be taken into account in decision-making related to climate change. And I'm interested in exploring whether there's an avenue for litigation to push this right for a right of participation, which is more sustainable and gives dignity to young children and future generations. And there are many cases that I can discuss and I can't. So Jimmy mentioned our series. Here it is. There's 4 of them. Climate change coming soon to a court near you. And it's available on ADB's website to download for free. So turning first to this, how are youth litigants framing their arguments? And so the overwhelming majority of cases that we're seeing are youth litigants relying on rights-based litigation. And I'm going to focus on Asia and from Australia. I'm working in Asia, so I want to focus on that. And I really want to stress, I know this is 30 years ago, but almost 30 years ago, the Supreme Court of the Philippines allowed children to sue on their own behalf and on behalf of future generations in the case of Opposer versus Factorin. And the court accepted that there really are some rights that have existed from the inception of humankind. And whether they're in a constitution or not, young generations and future generations should have the benefit of those rights. So let me come forward to the present and look at 2 cases from Asia right now, looking at constitutional rights-based cases for climate change. And one is from Pakistan. Both cases rely on constitutional rights It's such a great way to overcome barriers to standing and to have a ready right to sue. In Pakistan, a 9-year-old has challenged the government's decision to mine coal in the Thar Desert. And she says that doing so will increase emissions, which will further destabilize Earth's climate and undermine Pakistan's international climate commitments. And she says Pakistan has an obligation to do its share in limiting the impact on climate change. So that she's also picking up on that language of do its share, which is similar to Urkenda. The second case is an interesting case from South Korea. It's a recent case filed last year by 15 youth litigants, and they're challenging the constitutionality of 3 things. One is the government's emissions standards, or its targets rather. They're saying they're insufficient and unconstitutional. Second, they're challenging the constitutionality of the government's failure to meet its 2020 targets. It didn't do that. And thirdly, this is really interesting. They're challenging the framework legislation that South Korea has in place. And what's interesting is that they're saying that the law has delegated too much in relation to who can set emissions. There should be more interaction. And they're saying the law and the Legislative Assembly should pass a law that contains standards around setting greenhouse gas reduction targets, as well as measures to make sure those are achieved. And it points to the government's failure to achieve its 2020 targets. So in saying that the government hasn't adequately protected their constitutional rights, the petitioners point to the science, IPCC reports, government reports, and they also point to overseas litigation and cases that have accepted climate science and accepted that climate change undermines climate rights. Okay, let me move on to this concept of taking children into account and climate democracies. So in April of this year, the Supreme Court of Pakistan issued a decision called, I haven't got the name of it, DG Khan Cement. And so this company challenged amendments to environmental regulations that said it couldn't build new facilities or expand facilities in these fragile areas. It ends up in the Supreme Court, and the Supreme Court says, okay, but the reason these areas are sensitive is that they're aquifers, water aquifers. And we can't consider water in isolation anymore, given climate change. In Pakistan, it's very vulnerable to climate change and water scarcity. But what becomes relevant for children and intergenerational justice is that the court acknowledged that when it adjudicates this matter, it's adjudicating upon the rights of future generations. And in this regard, the court said, how will future generations look back on us? And what legacy do we leave them with? And the court believes that it and all courts have an obligation to decolonize our future generations from the wrath of climate change by upholding climate justice at all times. And this is an important decision because if you remember, it also talks about the concept of climate justice and climate democracies. It comes from a jurisdiction that issued the Lagari decision. And in the Lagari decision, the court said, the government's not doing enough. We will set up a climate change commission, and the court made directions about who should be on that commission. So is this opening the door for children to push for rights of participation? The next case is from Australia. And I raise this case because it doesn't use constitutional rights. Youth litigants challenged a ministerial decision to extend the life of a coal mine, and they relied on statutory obligations and the law of negligence. So the court has found, the Federal Court of Australia has found that the Federal Minister of Environment has a duty of care under the common law of negligence in Australia to protect Australian children from personal injury flowing from the effects of climate change when making these kinds of decisions. And further, that the minister must consider the potential harm to children as a mandatory relevant consideration to be considered as a matter of administrative law in determining the application. So just very quickly, I have two takeaways. Of course, youth litigants have rights, they have a voice, and that voice is being recognized commonly in rights-based litigation. But if, secondly, climate democracies are to emerge, as the Supreme Court of Pakistan says they should, is it enough for children to merely have a right to be considered? And are there avenues for children to push for the right of participation? Thank you. I'll leave it there. I know we have to be brief.
Thank you, Brini. That was fantastic. A fantastic recap of a very complicated area of law and ethics. Next, we have Julia Olson. Julia, the floor is yours. Thank you.
All right, I'm going to share my screen here. All right, everyone seeing that?
Yes.
Is that working? Okay, great. All right. Thank you, Jimmy and Stephen and Sophie and everyone. It's a pleasure to be here talking about this really important conversation. And I just wanted to start by, for those who aren't familiar with our Children's Trust, Jimmy did a great job of talking about our origins, and we operate under three principles. One is that we're only representing young people and the rights of future generations to a safe climate. And in doing so, we use the best available science and advocate only for science-based and legally enforceable remedies that are systemic in nature. So we don't challenge piecemeal projects, and we're seeking to protect children's basic human rights. And we work globally, and so we look for wherever in law those human rights are embedded, and that's how we bring our claims. And I'm here to highlight this case in particular. These are my amazing 21 clients in the Juliana litigation. When we started, they were ages 8 to 19, and it's been 6 years in, so they have grown quite a bit. And the Juliana case, it is many things. It's the most complex case I've ever litigated, but at its heart, it is a children's case. And the claims that they bring are their rights to life, to liberties, to their personal security, to equal protection of the law, and to those public trust resources on which their lives depend, such as the air, the water, the oceans, their shorelines, and ultimately their climate system. And these claims are brought under the Fifth Amendment of the US Constitution. And we have a whole team of amazing experts that focus on all the very aspects of climate science and economic harm, and also the energy transition solution experts. But we have about 6 experts in our case that focus on the physical and mental health harms that climate change is causing these particular young people and all children. And this is just a chart that shows that those harms begin in the womb and continue throughout adolescence and really inform the kind of life that children will lead. And this is the life that 2 of my plaintiffs are leading, and actually more than that right now. This was August 2020 during the extreme wildfire season out on the West Coast. This is in the Pacific Northwest. And several of our plaintiffs suffer from asthma and other respiratory issues, and that's just one of the types of physical impact that they're bringing forward to the courts. And when we went up to our Court of Appeals in this case over the last couple of years, they identified the exacerbated medical conditions, damage to the homes of these children, and psychological harm were among the injuries that these youth could press forward in their case. And so I want to step back to the science for a minute, because I think it's a really important part of the conversation about how we define constitutional rights and human rights of children in the context of the climate crisis. And one thing that we do is go to our experts and say, well, what would actually really be protective of them? And what scientists say across the board is it's really the Earth's energy imbalance that is leading to the rising temperatures and leading to all of the other consequences. And that the only way to really stabilize Earth's energy imbalance, as scientists currently understand it, is to bring our carbon dioxide levels back down beneath 350 parts per million. So standards that have been set in international agreements and other places that are set by those political players who, as Brian said, are hearing from the right people about how to set those standards, are setting standards that we think are not protective of children based on the scientific evidence. So jumping back to where we're at in the case, we received a ruling from our Court of Appeals that there was a substantial evidentiary record that our federal government in the United States had long promoted fossil fuel use, despite knowing that it can cause catastrophic climate change, and that failure to change existing policy may hasten an environmental apocalypse. Really, really powerful language in this opinion. I encourage folks to read it. But the key example I wanted to bring here is that our cases are really challenging, for the most part, the affirmative policies of government that continue to perpetuate the crisis. However, the Court of Appeals, when they issued their opinion, it was a divided 2-to-1 decision. And they also found that these children did not have standing to be in court, because they found that while they were injured and the government was a cause, that the courts don't have a role to play, and that where the children really need to go is to the political branches of government or to the ballot box. And remember, many of these children don't have suffrage rights, so can't go to the ballot box, which is also an important topic. And the dissenting judge made that point precisely, saying that fundamental rights may not be submitted to vote. They depend on the outcome of no elections. They are beyond the reach of majorities and officials. So the next steps in the case are we have a hearing back before our district court judge, our trial judge, on June 25th. We've slightly amended our complaint to try to address that issue of redressability and focus on the need for a declaratory judgment in the first instance. And meanwhile, the district court judge has also ordered the parties to engage in settlement negotiations, and really pointed out in that directive that she thinks that this crisis is going to require all 3 branches of government working together to resolve the issues. And then in exciting news, this week, we had 17 states that are controlled by the Republican Party here in the US file a motion to intervene to join the Juliana litigation as defendants and try to stop the youth from proceeding with their case and or stop any settlement agreement that they may reach with the government, with the federal government. So we're now contending with that. And I just wanted to show this as we dive into Ramin's presentation and then ultimately our conversation today. This is now an outdated map of all of the rights-based cases happening against governments around the world. Most of these are being brought by young people or by groups of citizens that also include young people. And just in the last week, there are 2 new cases filed against the government of Italy and of Poland. And there may be more, but we just have more and more cases being brought by youth all over the world. So it's very exciting. And I will say that among the courts, the United States is really an outlier in terms of denying children the right to even be heard. So we're seeing courts all around the world accept these cases say that they have a role to play in democracies. And the US is kind of an outlier, and we need to talk about that because the US is obviously a very important player when it comes to climate. So thank you so much. And Ramin, you're up next.
So thank you so much, Julia, for those wonderful remarks and just the inspirational role that you're playing in this, what many have called the case of the century. Ramin, the floor is yours. Thank you.
Thank you, Jimmy, and thank you, Briony and Julia. I feel a little bit like an imposter sitting in the company of you all, but I'll try my best. And I would say, in particular, I think Julia's work has really inspired our case, which I'll talk about now, which is before the UN Committee on the Rights of the Child, in particular, how we've shaped our claims and the arguments that we've made. So we, as Jimmy said, we along with the law firm Hausfeld, as co-counsel, represent 16 youths from around the world who wanted to bring a climate change case internationally before the UN Committee on the Rights of the Child. The claim that the petitioners are from many different countries, from different continents, and they're quite diverse. Some of them are indigenous peoples. Some are from small island states like the Marshall Islands and Palau. And they range from about 12 years old to, I think the oldest is 17 at this point. The claims that we have brought are based on the rights to life, rights to health, the right to culture, and the principle of best interest of the child in decision making. For those of you who are not familiar with the Committee on the Rights of the Child, they're basically the body that monitors compliance with the convention, which is the most signed, I think, or ratified human rights treaty in the world at this point. I think the only country who hasn't ratified it is the United States. But we're also limited in terms of who we can bring a complaint against, because the states who have ratified an optional protocol, which basically accepts jurisdiction of the committee, are the only states who will accept the complaint against it. So that really left us 35 of those 192 states, and notably absent are China and India. So the states that we brought the claims against, Brazil, France, Argentina, Turkey, and Germany, are the five basically top emitters of that smaller pool of 32 states, and they're all members of the G20. So they're kind of historically bigger emitters, but also larger emitters, and some of the biggest economies of the world. So that's why we brought the case against those states. The claims are based on injury that has happened already. And as Julia said, a large portion of that is emotional and mental injuries, the fear of climate change and how it's quite debilitating. But also in our case, we've really focused on risk exposure. So basically, it's pretty well established under human rights law that if you're exposing a person to imminent risk that's foreseeable, that's an actionable claim, particularly under the right to life and right to health. And in this case, we're arguing that the actions that they're taking now obviously will manifest later during the life of our youth petitioners. So where the case is now, well, let me back up. What are we asking? We're basically asking for declaratory relief, which is to say the committee is recognizing that the policies and climate emissions policies of these 5 countries are insufficient, and it's insufficient to protect these rights. But we're also asking for the committee to recommend that the states take climate action within the framework of their best available resources, which is the language really in Article 4 of the Convention, based on a 1.5 degree target. And I realize that that's not the most protective I completely agree with Julia that even at 1.5 degrees, you're going to see, vast human rights violations and harm around the world. But for us, with the committee, we felt really like already this is a really big case for the committee. They're not environmental lawyers, and if you look at their bios, almost no one has environmental background, much less half of them aren't even lawyers. They have academic backgrounds in other fields other than law. And so we felt like we had to kind of base it on the strongest standard that was supported by the IPCC, to link it to an international standard. So we felt 1.5 was a reasonable request, but we have said best available science. And I think it provides us flexibility to ask for stronger standards. And so basically what we tried to also avoid was asking the committee to specify specific policy actions, like take out this subsidy, take out this coal plant, and keep it more general, because again, we felt like if we got into the weeds in terms of our remedies, it would really scare the committee away. So I think I have like 2 minutes left. I'll just explain where we are, and I'm happy to answer questions about it. But we filed a case in September 2019. The committee decided to split the case up into 2 phases. So the first phase is admissibility and then merits. And admissibility really is focusing on exhaustion of remedies, sort of establishing theories of causation and jurisdiction, and making sure we meet sort of like the minimum, levels of claims. And just in the last 2 weeks, they decided to split the case up and have 5 different hearings against each of the countries. And the committee held these hearings on Zoom. So we had to have 5 different sessions where we argued our case, and then each country came and argued their case. And as we learned, this is the first time that the Committee on the Rights to Child has had a hearing in any complaint. So it was really an amazing experience. It's only the 3rd time that a treaty body has had a hearing with respect to any case. So it's just to put it in perspective, it felt like a kind of momentous moment. And the committee, surprisingly, in the opening statement of the chairwoman, she said, they were incredibly enthusiastic about the case. We were all shocked. They were saying how courageous the petitioners were, how this is a landmark case, how, they're really excited to have it before them. Whereas we came in kind of thinking, oh, they're very skeptical, and they might be. They could throw it out on exhaustion, but I think, all the petitioners had a chance to testify before the committee, share their stories, and it was really quite powerful. So yeah, that's my time. I'm happy to talk more about it, and I'm really excited to engage in the discussion. Thanks, Jimmy.
Thank you, Ramin. And the world is owes you a debt of gratitude for bringing this case and all these firsts that you just mentioned. Speaking of firsts, we have a series of questions, and we'll turn to the first one. So the next part of our panel is a conversation, is a discussion. Think about like a family gathering or something where people are sitting around a table discussing or arguing about things. So not that we have that exactly in mind, but just to talk about things. And given that we have such an expert panel, so the first question for the panel really gets to the legal claims behind these various actions in the Asian Pacific region, in the United States, before the Committee on the Rights of the Child and otherwise. So here's the first question for the panel, and Brianna, we'll begin with you. It's what is or are the arguments that children are making that they have a right to a healthy climate under international, regional, domestic law, these cases that you addressed? Thank you.
Yeah, sure. So For the most part, in the South Asian jurisdictions, it's really this notion that climate change undermines their capacity to access rights, or it undermines their life. So they really are pinning it on domestic law, not so much international law. It's really coming into their domestic legal frameworks. And it really depends on the jurisdiction. So, in Pakistan, they have rights to life, but also rights to democracy, rights to dignity. So they're really used to pegging it on each of those rights, and it really depends. I've seen in other jurisdictions it's right to equality before the law. So it's really just that fundamental notion that you can't have a full life with climate change, and they bring in the science of how that gets affected. Interestingly, both the case from Pakistan Ali and Pakistan and Ridhima Pandey against India argued that the target, a carbon budget, should limit atmospheric CO2 to 350 parts per million, and that failure to do that would result in catastrophic climate change undermining life.
Okay, thank you, Brini. Julia, thank you.
Yeah, I think a lot of the rights that children are asserting are found in constitutions, and most constitutions in democracies have some provision for protection against government endangering your life, or taking away your freedom, liberties as defined by that nation and its laws. Australia is actually one of the few that doesn't have as clear a set of Bill of Rights. So some countries don't have that and have to look elsewhere. And a lot of the law in the United States interpreting our rights to life and liberty and property come from our Supreme Court. And so there's actually a long history of Supreme Court decisions in the United States that are really children's rights cases, even though the court itself has not put together these cases as children's rights cases, but they, start in cases like Brown versus Board of Education, which protected the rights of Black children to equal education that wasn't segregated. There's a case called Burnett, which was the right to essentially free speech and religious expression and not have to say the Pledge of Allegiance. And then there are cases about children's rights in the criminal justice system to not be imprisoned for life or to not be put to death, which we unfortunately still do in the United States. And then cases around children's rights vis-a-vis the choices their parents make or who their parents are. So if their parents are undocumented immigrants in the United States, children have been found to have rights. Or if their parents are LGBTQ and want to marry, children have been a part of those cases. And so we see this thread of protecting children in a lot of our jurisprudence here. And I don't know what that's like around the world, but it would be interesting to see if there, that lineage of case law.
Thank you, Julia. Ramin?
Thanks, Jimmy. So yeah, I mean, our case in particular, I see as really supplementing all these amazing domestic cases that are being brought almost usually always based on constitutional rights. Obviously, there's examples like Brioni gave in Australia. There's also a lot of cases where not just children, but you're challenging fossil fuel projects or infrastructure projects that have really a huge impact on climate emissions. But for us, our arguments, like I said, are based on rights in the convention that really are in the constitution of most countries. The only exception really is the convention itself is not self-executing in a lot of countries. So for example, in Germany, recently there's this quite landmark decision, but they haven't actually, and just in fact, this week, the parliament denied again the attempt to execute the convention. So you can't bring a claim based on the convention. So what happens is you have certain rights, like the right to culture, which are not really protected in Germany in the same way that it would be under the convention, particularly for indigenous peoples outside of Germany. Also, the right to have decisions made in the best interests of the child. That's absolutely one of the most important rights in the convention. Many countries have not recognized that right, including Germany. They have a welfare kind of standard, but it's not nearly as protective. So what you get is cases are being brought by youth, but in a lot of times the country doesn't recognize this kind of more protective standard for children, which you're supposed to consider when making policy decisions that affect children. And so, I think that's one gap where I see, just in terms of availability of constitutional rights in some of the countries we've seen, and it's one area where we were hoping to sort of get the committee to really opine on more strongly.
Thank you, Ramin. What an interesting and innovative use of that best interest of the child standard. Before we move on to the next question, just any final comments from any of the panelists about this question, Brianne?
Yeah, the comment about the self-executing rights is such a great point. And Asian courts have actually done interesting things with these. So what we look at in the third of our reports are the different constitutional rights in the countries we survey of South Asia, Southeast Asia, and the Pacific. And we break them down by, your self-executing rights, but also directive principles or policy of state, and then the implied rights. So India is such a great example of a jurisdiction where there's no right to environment under the constitution, but there's a state directive to care for the environment. And so what the Supreme Court said is, well, we've got a right to life, and then we've got a direction to care for the environment. So now we're going to extend this constitutional right to life, give it an extended reading, and say that it covers environmental right. And that's the case of Virender Gal and Union of India. So we are seeing Asian courts have got great examples of how courts have dealt with this issue of whether it's a directive, whether it's self-executing or not.
Wonderful. Thank you, Brianne. Anything else before the second question? Okay, so the next question is related. It's related to the one we just asked about legal claims, but it domesticizes the question in constitutional terms, and it's as follows. And we'll begin with Julia on this one, and then Ramin, and then Brianne. What is the importance of a declaration of a constitutional right to a safe climate system for rights of the child? Thank you, Julia.
I think that a declaration of law on this point is vital to the survival of democracy and children's future and intergenerational justice. And I mean, there are some constitutions, as Jimmy well knows, and has, worked to compile that, excuse me, actually protect environmental rights explicitly or climate rights explicitly, but there are many that don't. And so for courts to really evaluate what it means to protect human life and human liberty, and the essence of the climate system and our atmosphere, our global atmosphere, is foundational to life and liberty. It seems like such a basic, simple task to me. Yet it's really important. And we can see throughout history that when courts declare things, especially in democracies that have been around a while and where our systems work well, it can be transformative. And so some of the most polluting nations on the planet, if courts would step up and really declare those rights and the infringement of those rights, I think it would really assist the political branches of government and, in fact, cabin their conduct on the climate and energy systems that we have today.
Thank you, Julia. Ramin?
Thanks. Yeah, I don't really have much to add. I completely agree with Julia said. And maybe just to clarify, Jimmy, are you asking if there should be a specific right to a safe climate as like a sub right of a right to environment or on its own?
Yeah, not necessarily as a standalone right, but it could be. There are 8 countries by my count, by some other counts, 9 countries
Yeah.
that reflect climate change in their constitutions. None of them provide a constitutional cause of action. So I think that's the basis of the question is what's the added utility of constitutional protection of a stable climate?
Yeah, I mean, like Julia said, there a lot of countries don't have it, and it hasn't stopped. I mean, you just really have to push forward with the framework you have, and you can be successful. But having a right like that, I mean, there's so many positive elements that you could draw from having a right like that specifically that's enforceable. Obviously, it focuses great attention on climate change in a way that not having that right available doesn't. I mean, and it gives it a sort of normative strength to bring claims in courts. So, I mean, I'm skeptical that we'll see extensive adaptation of that kind of right, and certainly in the international sphere, as we know, it's been a struggle just to have the council recognize a right to a healthy environment, and that's an ongoing battle. But I mean, I think a right like that would be fantastic. But I'm a little bit on the well, let's not wait around and just go forward as we've seen.
That's a great point. Priyanka, what do you think?
Yeah, I agree with everything that's been said before, and it's hard to add much. I guess I think one thing that we tend to forget is that judges find this work isolating, and they're always concerned about interfering in the separation of powers. So it would give greater clarity. It's a very clear direction to judges that they can implement the law and enforce it. But having said that, in the absence of it, judges in many parts of the world are proceeding for the reasons described. If there's not a safe climate system, many human beings are going to die. So, and I liked the point made in the latest decision of the Supreme Court of Pakistan in DG Khan Cement about climate democracies have to really consider upholding the rule of law in this climate emergency. So I think courts are already asking that question. So of course it would add so much benefit to people to have that right. Now, I'm sure there are many governments that would be concerned about the floodgate of additional litigation. But the point there is that people are suing anyway. So sure, there'll be additional cases, but it's not going to stop people going to sue for their right on this existential crisis anyway.
Exactly, yeah, existential crisis to be sure. So before we turn to the third question, are there any further comments from the panel for the second? So as we turn to the third question, thank you, Julia. It involves this, what you're looking at on the screen, everybody. And these are all these cases. As Julia mentioned, there are more cases that have been added just in the last several weeks. They all have claims, right? They all have legal claims, but they're wildly disparate. Some of them are arguing in favor of a right to life in the face of the climate crisis, this existential threat, as Brianni just mentioned. Some a right to dignity, including the Ashkala Hari case and the Consumen case, which comes from a leading jurist and enthusiast for dignity under law, Justice Ali Mansour Shah. And there's a separate suite of cases that promote that right to dignity in the climate context. Thank you, Julia. And there are other cases involving a right to health. pushing for that. Others involving a right to water. Others before, as Ramin mentioned, like before the Committee on the Rights of the Child, and so on and so forth. I could go on. There were all those cases. And the outcomes, I guess the question is, what difference do they make? Are they simply, and I mean that advisedly, are they simply domestic outcomes affecting only the jurisdiction in which they're announced? Do they have precedential value? And to what extent are they or should they be persuasive elsewhere? So it's a loaded question, no easy answer. But Briani, I'd like to begin with you with that one. Thank you so much.
Wow, there were so many questions. To what extent, I can deal with precedential from the Australian perspective, but there was something that I wanted to talk about from, to what extent do they make a difference? This is something that we talk about a lot with our judges when we work with them. It's really easy to think that it's the international frameworks that need to make a difference. But actually, when you look at all of these cases, they're all saying we can only take action in our own backyard, in our own turf. So it all has to add up. And that's what the court was saying in Agenda. And that's what many courts are saying. We all need to do our share. It's a collective problem. So yes, they all add up. And yes, these cases make a difference. I don't know if you would like the rest of the panel to comment before I move on to Australia. Sorry, the other point that I wanted to make is, I think, again, to come back to Asian litigation, something that Asian courts, especially South Asian courts, have done so well was to pioneer these writs of continuing mandamus, which have now been picked up in the Philippines. And that is to hold the matter open and to require the government to come back and come back and come back and report on its progress. So, you could say sometimes that hasn't worked that well, but in the case of Ligari, the court held the commission open and required it to keep coming back until they had achieved at least 66% of the priority action items under the Pakistan climate change framework. I'm sure there are skeptics, but I think that is such a fascinating tool that has been developed in this region of the world that other courts could really pick up and run with. And that would be one way that courts could make a difference, is to really keep asking the governments to come back and report.
Yeah, that was a particular device, again, invented in some ways by Mansur Ali Shah. And it could serve as a model for how to address these kinds of issues or implement climate remedies going forward. And before we move off of you, Briani, I would invite you to tell us about the precedential or controlling impact of the Sharma case from Australia, if you'd like.
Yeah, it's really fascinating, and thank you for asking. So it's a decision of a single judge of the Federal Court of Australia. So Australia is like any federal jurisdiction, you have different hierarchies of courts. And the federal court is within the federal jurisdiction, looking at federal laws. And then alongside that, you have hierarchies for the different state jurisdictions. The apex court in Australia is the High Court of Australia. But what's interesting about this case is that the federal court is creating a novel duty of care under the common law of Australia. So, and Australia has one common law. So you might have state courts saying, okay, well, but that's not part of our hierarchy. So we don't think necessarily that we're bound. So technically it would be anything below the federal court in the federal jurisdiction and tribunals, not necessarily state courts. But like I said, there's this one common law. And I think courts would find it really persuasive. It's an incredibly well-written decision. It's reasoned. It refers to many High Court of Australia decisions on precedents. And the other aspect to consider, it's about mining permitting. So within Australia, states own the resources and they're responsible for the lion's share of mining permitting, but some of the permits must go up to the federal minister for environment. And so what you would see is one of two things. If state courts were to apply a different test to what's being applied at the federal level, you'd end up with a ridiculous result, right? Where they're approving and then it goes up to the federal court and it can't go past them anyway. And so then the second aspect of that would be that most of the decisions have to go up to the federal jurisdiction anyway, particularly if they're looking at water or taxation or cross-border issues. So you could bring this test in at the federal level anyway. And so I think that's why the state courts would really pay attention to the Federal Court of Australia decision, even if it's within a different hierarchy.
Yeah, and developments in Australia that you mentioned, I think also underscore the difference one human being can make or one court can make. Like the decisions from Judge Preston in Australia, or Justice Shaw, as I mentioned, in Pakistan, or the Inter-American Court of Human Rights, or the Committee on the Rights of the Child, right, Ramin? That's to come. But let me get your thoughts, Ramin. You're next, and then Julia on this question. Thank you so much.
Yeah, it's a really hard question to answer. There's a lot in there. I mean, I would definitely say all of these cases, some have not been successful, some are still being tried, some have been successful. And I think what at least for me, what's been remarkable is just the sheer amount of cases that have been brought in the last 5 years and just increasing. And I think lawyers in particular are reading all these kind of cases. They're kind of learning from the cases that have been brought. Like I said, we really learned a lot from Julia's work. And I think also judges are reading these decisions more and more. I mean, our agenda, now you have the Neubauer case. The Neubauer case, and I saw there was a question about it in Germany. I mean, that court, I think the case has some major problems, and it certainly dismissed most of the claims that were brought on the right to life, health, property, and it dismissed even a 1.5 standard. But that being said, the court really has some gems in that decision that I think draw from previous decisions, previous jurisprudence in other countries that have paved the way. And I was just reading the other day the Portuguese youth case that they've brought to the European Court of Human Rights. And again, I feel like it's really built on these previous cases. I mean, we're not seeing like totally new arguments. We're seeing a lot of similar arguments that are being molded into the whatever framework you can use within your country or within your treaty or within your convention. But fundamentally, a lot of the arguments and the relief are very similar. And I do think it's just going to grow and keep influencing and grow and keep getting refined. And yeah, I see really a lot of value moving forward.
Ramin, if I could ask you a quick follow-up to that, which is about the convention we haven't mentioned yet, the European Convention on Human Rights, which early on had environmental applications or applied the European Court of Human Rights applied Articles 3 and 8 and 11 to environmental contexts. Now, to what extent do you think the European Convention can continue to keep up with climate cases and other situations involving this existential crisis? Thank you.
Thanks for that really easy question, Jimmy.
Another easy one, yes.
Okay. I think it's a challenge, but as we've seen, the European Court's quite dynamic. And I think, with environment, I see the biggest hurdle is their test for jurisdiction, which is based on effective control in a quite narrow sense. But that being said, that test is also dynamic, and there's some great precedent in other court systems that really take it out of this very narrow military-oriented test that they've sort of applied before. And they have some precedent too, where it's starting to now, especially recently in the last few weeks, even to move that test. But I think the other challenge with the European Court is their wide margin of appreciation that they give, and that sort of discretionary nature. But that being said, I think, yeah, I mean, I'm quite positive with this case before it. I think the court has stepped up before to sort of move their jurisprudence, move their standards forward to meet sort of these bigger threats. And I don't see those as insurmountable hurdles here.
Okay. Thank you, Ramin. Any other comments from any other panelists on that one?
I have something on the precedential part of the question, Jimmy, and that is, I think the precedent in these cases is enormously important. And what we've seen in the United States is in our state cases, you know, we've had well over a dozen state cases in addition to our federal case. And when we lose on issues like the political question doctrine or standing, the government will string cite all of those cases in a different state, even though it's not precedential, it's persuasive to those judges. And after the 2016, the first really big decision in the Juliana litigation, where the court did say that there was a right to a climate system capable of sustaining human life, and we overcame all the jurisdictional hurdles, that decision was cited by others around the world in support of efforts going forward. We've relied on the agenda decision. And actually our judge in the 2016 opinion, I think it was in that order, she cited the Miners Oposa case that we started this whole conversation with. So judges around the world will look to other courts. And I think even if they're not citing to those opinions as precedential, they are certainly reading them and they are following what's happening. And so the way we as lawyers litigate these cases, and you know, later I want to talk about that science piece because that too creates precedent. And so it's really important, I think, that we're careful in how we build this emerging area of law.
Thank you, Julia. Great points and good catch. Thank you. The next question is also another easy one, and Ramin will begin with you and then hear from you, Julia, and then Brianni, which is if courts are willing to compel the creation of commissions like in the Ashkelahari case, or set emission reduction targets like in Urgenda, should youth litigants be demanding a seat at the table in planning a right to participate in a country that recognizes climate democracy? Again, another easy one, Ramin, but we'll start with you. Thank you.
Thanks, Jimmy. And I guess the answer is yes, absolutely. But I would bring it back to, again, this right to have decisions made in the best interest of the child. It's really important as a guiding principle when it comes to decisions that affect children. And you know, children, like other groups who are in vulnerable situations, like Indigenous peoples, they're particularly going to be affected by climate change because these harms are going to manifest not necessarily for me in the same way that it will for my children, you know, who are 7 years old in 40 years. So, and that's something that the German court recognized as well. But I think it's not enough just to have children at the table. You really have to orient your decision making to take their interest as a prime kind of consideration. It's just not enough to kind of check the procedural box of, I mean, there is great value in participation, but there has to be something more, in my opinion. And if that principle is really taken seriously, I think it can really shape how those interactions are sort of done moving forward.
Thank you, Ramin. Julia?
Yeah, I think children are brought in to working groups and talking groups and as showpieces and all the time without really given power. And so I think this is really a question of power. And so if children are going to be brought in or youth brought in, they need to have power at the table and not just a seat at the table. And I think if we were to think about a group of adults who would, maybe in combination with children, best reflect the interests of the child, it's pediatricians. Of all the people I work with in all of these areas, right, of adult expertise, it is pediatricians that understand this better than anybody, because they live it, they see it, and they are really rising up. And so I kind of like the idea of pediatricians and children, coming together to have actually a power seat at the table in any type of commission that would be formed.
That's a great suggestion. Brianne, what do you think?
Yeah, that's why I asked this question. If you have a jurisdiction like Pakistan or many South Asian jurisdictions are very willing to direct commissions to be formed, what is it that courts can be doing to start ensuring there's diversity on those commissions? So not just children, Indigenous peoples, people from minority groups, women, so that we just don't have this one prevailing view that's a bit paternalistic in how it approaches decision making. And I'm going to raise something else just because it's fascinating me and I'm thinking about it. The work of Roman Krasanik in The Good Ancestor, which is referenced in the decision of D.G. Khan, and talking about, in his book, he talks about how in economics we tend to discount future generations, which is how they end up being enslaved. So maybe economists need to be involved in these discussions so that we can start saying, okay, when we're doing this planning, how do we value the rights of future generations in the same way as we value these current generations? And that brings to mind the work of Kate Raworth on donut economics and how we bring everyone into the donut. So sorry to bring economics into the discussion, but I also see them as 21st century economics as another a set of ideologies that needs to come to the table and to help children and future generations to have power at the table.
Thank you, Brianne. Julia, did you want to add to that?
Yeah, thank you for raising that issue of discounting. And I loved seeing Roman Krishnar cited in that opinion. I sent him an email right afterwards. He didn't know he was cited and he was blown away that he had made it into a judicial opinion, which was wonderful. I love that book, highly recommend it for those who haven't read it. And he does a beautiful job of explaining the discount rate. I had a conversation last week with our expert, Joe Stiglitz, who is a Nobel laureate economist and works on this precise issue. And he and Nicholas Stern just published a new paper on what the social cost of carbon and the discount rate should be right now. It's a 2021 publication, also recommend that. And Joe Stiglitz explains it in a really simple way that I love. He said, if we want to treat people in the future the same as ourselves and value them the same, then in the context of climate change and the risks involved, we would use a 0 discount rate. We wouldn't use one. But if we think they might be a little bit better off, the highest we would go is a 1.5% discount rate. And if we think they're going to be worse off, we need a negative discount rate. And just for reference point, the United States right now, in reassessing our discount rates, which have been 3 and 7%, is looking at the lowest 2.5% discount rate. So even under the Biden administration, we're seeing that the way we're going to discount the lives of children in the future and future generations is still completely inappropriate in light of the risks that they face.
That's super interesting, Julia, and also just incredibly depressing. But thank you for teeing up that issue as well about economics. We have rights of the child, we have pediatrics. And is there anything else for this question before we turn to the next one, which is about science? All right, so the next question is, what is the importance of using best available science on Earth's energy imbalance to set emission reduction targets to protect children's rights? And we'll begin with Julia, and then turn to Brianna and Remy. Thank you, Julia. Go ahead.
Thanks, Jimmy. So this is my passion topic. And I think it is one of the most important conversations we have to keep having as adults. And I think Brianna, again, I just love this question you posed at the beginning. Who do I need to be for the law to listen to me? And then I heard Ramin speak about why they chose to, focus on the 1.5, which is the Paris target before the Committee on the Rights of the Child. And Ramin, you said that you thought it was, given the sort of the skill sets and the fact that this was the first time this kind of thing was coming before the committee, that those adults might have limitations, right? And being able to really reckon with the full scope of what's happening. And I think I want everyone to really think deeply about how we as lawyers and litigators, as experts in our fields, approach this issue, because we tend to do it with that exact framework in mind. Adults are limited. We have limitations. We're not willing to do what's necessary. We have political calculations. We have economic calculations, right? But the very harsh reality is that a 1.5 degrees Celsius planet does not protect human rights of children. We melt all the ice on the planet eventually at a 1.5 degrees Celsius target. And I can tell you, that's about 50% hotter than it's been on the West Coast. Like the West Coast of the United States will burn perpetually, right? The Middle East and North Africa will become unlivable. Like we will lose places, coastal areas. And so I think we need to start really paying attention to the science and having that directly inform what it means to protect children's rights. And courts are, right now in many, many cases, they are starting to write that 1.5 degrees Celsius is the best science on protecting the climate, because that's what lawyers are bringing to them. And it's just not accurate. 1.5 was a politically negotiated number that is not based in any science of protecting the planet or children. And so if I could leave people with one message today, it is that those numbers are really, really vital. And we should be honest about with courts and our young clients and what it really means for children and their futures when we're advocating for levels of heating that are not safe for them and trying to embed that in law. So that's my soapbox and my advocacy for my young clients. And I look forward to talking about that.
Yeah, that's a great message, Julia. Just being honest about it. Now, what was it on Monday? The Mauna Loa Observatory announced that the concentration of CO2 in the atmosphere exceeds 420 parts per million, a level it hasn't been at in 4 million years, and never in the known geologic record. So anyway, it's just good to start from there, and also that the planet has already warmed in the last 100 years from an average mean temperature of 13.7 degrees Celsius to where it is now at 15.1. So it's already warmed about 1.5 degrees Celsius. So it's good to have our eyes open about that so that we can better see the crisis and situation we're in and what to do about it. Brianna, what are your thoughts about this science-based question?
Yeah, this is something that we have spent time working with judges on about climate science. So the first report in our series is our effort to explain it. We're not climate scientists, and we defer to the opinions of the experts. But the point that we make is that lawyers just need to get comfortable with the science and what it is and what it means and what the facts are. So Julia, you're so right. You know, the facts are there, the science is there, and we need to be explaining that to courts. I did love, was it Justice Alsop in the US, who made everyone come to court and give a briefing on what climate science is. And I think that's really important for judges. The judges that we deal with, many very, very talented judges, but often they're 30, 40 years out of university. Environmental law wasn't even taught when they were at university. They've got a busy schedule. They don't necessarily understand the concepts, but they're very interested in understanding the concepts. And I think, you know, in Asia and the Pacific, judges are much more receptive to hearing the science, probably because for the most part, the countries haven't really contributed to climate change. So they're kind of like the countries that have to deal with it first. So, you know, they're more interested in doing that. And I think the value of accepting the science in climate litigation is that it can be proven as fact. You know, science is getting better and better. You know, and we can rely on principles like the precautionary principle to accept the science. And once courts do that, it sends a very powerful message that it's not necessarily a political issue that can be swept under the carpet. We're dealing with facts here. So it takes it away from that, and it helps in some respects give clarity to the discussion, because too many politicians make it sound like it's a political issue. But when courts make these rulings and say, well, these are a matter of fact, it doesn't matter what your political persuasion is, it's just a fact. I think that's really useful. But thank you for drawing attention to the point about 1 degree. We do tend to focus on 1.2, 1.5 to 2 degrees, because that's what's in the Paris Agreement. And I think that this is an issue for courts. It's one thing that I saw in the Ridhima Pandey decision in the National Green Tribunal, where she brought this case, and it was a massive petition, 50 pages. They dismissed the petition in 2 pages, saying our environmental impact procedures provide for us to take climate change into account. But one of the issues that they're saying is, but the body of law internationally is 1.5 to 2 degrees. How can we really go outside of that? So that is an issue for courts in making findings that are contrary to the international body of law. And it's something that we might need to be working with courts on, because it's hard for them to go beyond what they think their legal ambit is.
Great points. And also it serves as a reminder as to what cases like the one Julia has brought are just trying to do, just get a hearing. You know, in the United States, we've never had a merits-based hearing on climate change. That's just, you know, astounding. Ramin, any final thoughts about the science part of this before we turn to the audience questions? Thank you.
Yeah, I have a few thoughts, but this is a topic that I feel like, you know, it just warrants much more discussion, because I agree with everything Julia said. I mean, I agree 1.5 is not, I mean, you're going to have, like I even said earlier, you're going to have major human rights violations with 1.5. We already have it with 1.1. I mean, if you look at places where that actually is 4 degrees of warming, and you look at like indigenous peoples, I mean, they're already, one of our petitioners already has lost his way of life almost entirely. But that being said, I also think that, you know, Paris is not strong enough, right? Well, it gives leeway, really. And that's the major problem with the German court. It says you could go to 2 degrees if you have adaptation measures in your country. And for us, 1.5 is really, you know, the reason, and we actually didn't specify 1.5, we specified to the, you know, based on best available science. So we tried to keep it flexible. But I also think judges, especially like the committee, if you're asking for a standard, 1.5 is already beyond Paris. it's way beyond Paris, because right now it's well below 2 degrees, and there's discretion if you're going to leave it to like the political kind of role of international climate policy. And 1.5, in our opinion, was already asking a lot of the committee to really, to have a holding saying that should be the standard at the very least. I agree, if you could get 1.0, that's the most protective by far. But I'm kind of like, we were torn, and kind of what Brioni said, we were thinking about like what is really practical in terms of what this committee of international experts in the UN would be willing, how far they would be willing to go. And already 1.5 is asking beyond what has been negotiated. And so, yeah, I think it's a really important question. I mean, yes, Julia, maybe you're completely right. If all these cases like Neubauer, they asked for 1.5, or Genda, all these cases, if they asked for 1.0, maybe right now that's, like we talked about precedent and influence. You might be totally right.
I think you can win it.
Give you full credit for, taking that position.
Ramin, I think if you ask, you might be surprised at what judges are willing to do. And I think to not ask is putting the burden on the children, and the burden needs to be put on the judges, right? Like that is their role, even if it's hard, is to step up. It's not for children to have to live with the consequences of adults who are too afraid.
Yeah, I hear you.
Those are great sentiments as well. And speaking of hearing, the audience portion of the program now is what we'll turn to. We're right spot on time. Thank you, panel, for a wonderful discussion of those questions, edifying and energetic and inspirational. The first question from the audience is from Roger, who asks this, and if we could just maybe spend 30 seconds or so each, if you have a response. Whoever would like to go first, it's up to you, which is, children absolutely have rights and they are absolutely entitled to be heard. Those are two absolutes. But do children have different or more rights than other humans? Who'd ever like to take that? Go ahead, thank you.
Yes. I mean, I think they do, because they're not just small humans, they're different physically and emotionally and in terms of their dependency. So they need things that adults don't need. And so the law should really account for that. And just physiologically, they bear the burden of pollution and climate more than adults do. And of course, they will live with it far longer. So I do think it's a different calculation when we're looking at the rights of a child.
Great points. Briani, Ramin, anything on that?
I wholeheartedly agree. And children have to bear the burden for longer, and it impacts their capacity for development. So these factors should be weighed in when judges are considering.
Yeah, I don't have anything to add to that.
Thank you. Yes, in American jurisprudence, children, as Julia mentioned earlier, even the US Supreme Court has recognized that children have different sorts of rights. So it's well established, one might say, deeply rooted in American jurisprudence that children have special rights. Which brings us to the next question from the audience, which is from Petra, which is about the German case. And she writes, he writes, I'm sorry, I don't know. The German Constitutional Court has recently strengthened intergenerational equity under the Basic Law. It held that the current emission amounts set out in the Climate Protection Act unfold and advance interference-like effect and are unconstitutional, sort of echoing the words of Judge Aiken in the Our Children's Trust case. I wonder what your thoughts are on that case and its potential influence on other courts. This would be the German case. So again, it's up to you as to whoever would like to go first is fine with me. Thank you.
I can go first if people don't mind. So I think I talked about this a little bit. That case, the youth there brought a claim requesting that the emissions targets be reduced to meet their kind of a 1.5 degree sort of global target, which we've talked about already. So I won't get into whether that's strong enough or not. But the court dismissed that. I mean, they also asked that, that Germany hadn't set targets past 2030. And so that violated this special article in the German constitution that's based on protecting future generations and the natural foundations of life. So the court dismissed the right to life, property, and health claims based on reducing emissions to meet the stronger standard. And it said Germany actually has quite a wide margin of appreciation to set standards and what protection levels. And it kind of made this weird test of mitigation and adaptation are intertwined. So when you look at mitigation, you also have to look at adaptation. And if you set mitigation standards or targets, they can potentially be less protective if adaptation measures can protect the population. But it's a really German-focused test because there were claimants from Nepal and Bangladesh in that case. And the court said, well, actually, we can't really apply this test to them because Germany can't undertake or guarantee adaptation measures in Nepal or Bangladesh. So really, their obligation is less protective towards these foreign claimants. And so all that was really like held at that case is, well, Germany, you have to set standards, what you want to have after 2030. It didn't direct them in terms of what those should look like, how strong they should be. And it suggested that they can be even 2 degrees might be protective enough. So it's a really important case in some ways because it really highlights some really important aspects around causation, around this idea that like our emissions are nothing compared to like the US's, so we shouldn't, like those kind of arguments that really addressed. But I still think that case, I think it could be a lot stronger from the court. But a lot of people are talking about how great that case is. But in my opinion, I think it has a lot of gaps. And, it's not as strong a case as I would have hoped for.
Okay. Thank you, Ramin, for that comprehensive, concise, and critical analysis of that case. Very much appreciated. For the last 90 seconds we have for this panel, I'd like to give each panelist 30 seconds or so to save the world. Brianne, you first, then Julia, then Ramin. Thank you.
So I think some of my points are really questions around what's coming up in the future with child's rights litigation. And that's why I wanted to explore this idea of children asking for a right to participate. A lot of the cases that we see really are focused on mitigation. So it would be interesting to see cases that are really running saying mitigation and adaptation, and we want to have a role in these planning processes, particularly for adaptation. There's just not enough thinking about how they should have a role in shaping their future lives and what that looks like so that we can give them dignity.
Thank you. Julia?
Looking forward, I'm just hoping that the US courts will really step up and at least follow the path of many courts around the world that find that children have the right to at least be heard and have their cases decided. I think that we're still at that very important step. And I'll say from the youth I work with, they care deeply about standards that will protect them, about their governments really planning for meaningful policies that will accomplish the emission reductions that they promise and the protection of sinks that they promise. And they want accountability for that. And they also really want a just transition. And I think the youth I work with, more so than adaptation, they are really concerned with the way the transition will happen and not creating more environmental racism and more injustice for their generation. They care so deeply about that. And so I think ways for youth to participate in that in a meaningful, powerful way is really important.
Thank you, Julia. Ramin?
Sheesh, I don't know how to say anything after that. But yeah, I guess I would just say I agree with what you both said, and in particular, I think the youth in our case also are really looking at a systematic kind of shift in the orientation of the economy, and the way that decisions are really being made right now are in the interest of corporation, things like that. And I just, yeah, I think it's really important to have their voice, because it really is what I think is the most protective voice for not just them, but for our planet at this point.
Thank you, Ramin. So let me finish with 4 quick thank yous. First, for our wonderful panel, Brianna Eels, Julia Olson, and Ramin Pijan, for a fantastic conversation. Secondly, Stephen Turner and Essex for a wonderful conference. Third, all of the participants in the audience who took the time to listen to these points of view. And fourth, children. I hope everyone has a wonderful day and a great weekend. Take care, and thanks again for joining us. So long.
Thank you, Jim.